us has been asked the question of whether an association can vote for a renter's cap. In short, the answer is that it may be possible, but it will only be effective against people who buy their unit after the cap has been adopted and recorded in the county clerk's office. The reason is that NRS 116.355 subpart 3 generally provides that if a community's declaration contains a provision establishing a cap on the number of properties leased within the community, that provision may not be reduced. So what if your declaration does not have an existing cap? The answer to that question is found in NRS 116.355 subsection 1, which generally states that unless the declaration contained a prohibition on renting units at the time a unit's owner purchased his or her unit, the association may not prohibit them from leasing the unit. Similarly, NRS 116.2117 subsection 6 limits the association's ability to enforce any use restrictions unless the restriction was in place at the time an owner purchased their unit. That language does leave the potential for a loophole. That is, the association may be able to adopt a cap on the number of renters within the community. However, that cap would only apply on a going-forward basis. In other words, the cap would only apply to individuals who purchased their unit after it was adopted and recorded. Therefore, if an association is seeking to adopt a renter's cap or another use restriction, all existing owners will effectively be grandfathered in. While Nevada law may allow for a cap on future rentals, a review of your community's declaration will also be needed to determine if there are any provisions which might alter the potential for a cap on the number of units available for rent within your community. Working with my office, we can develop caps on the number of rental units, but know that to the extent allowed, the association will have to take the long-term approach. For more information or assistance, please see our website at isaacsonlawlv.com or call Troy at 702-529-2559.